However, stating that under restatement of values of judicial life, where there have already been said, I beg your pardon, Your Lordship.
Guidelines.
Your Lordship, these guidelines are merely suggestive guidelines. Your Lordship, the Council expects only consideration of these guidelines under Article 51C because as stated, indeed, Your Lordship, the Council believes so. Indeed, Your Lordship.
Yes.
Conclude.
Yeah.
Now, once again, are you willing to go for a council or mediation? Ultimately, you want to save your family also. Are you willing?
The Council would disagree with that. The Council.
Are you concerned with right?
You don't want to consult with that?
The Council
you
is.
have made up your mind. No, I don't want this one.
The Council is clear with the mindset of the respondent. With due respect, Your Lordship. The Council would like to move further with the prayer. Much obliged, Your Lordship. In the light of arguments advanced, issues raised and authorities cited, it is humbly submitted to this Honourable Court to declare and adjudge that judges do have a right to subscribe to Facebook and invite and accept friends, however subject to reasonable restrictions. The impugned order dated August 2014 by the High Court of Sindhia under the appeal of Section 19 of Families Court Act 1984 is not null and void, and the petitioner is to be held guilty for mental cruelty under Section 13 Clause 1 Subclause 1A of the Hindu Marriage Act 1955. The court may also be pleased to pass any other order in the light of equity, justice and good conscience. For this act of kindness, respondent shall duty bound forever pay.
Firstly, regarding the question of competence of this Honourable Court regarding guidelines, the submission of the petition is that under Article 142 and 145 of Constitution of India, 145 Clause 1 Clause C, that relates to the enforcement of fundamental rights, this court have to power to make the guidelines, and in Union Carbide Corporation versus Union of India, this court had said that in the first. The court observed that the power conferred under Article 142 Clause 1 coupled with plenary power under Article 136 empowers the court to pass any order which it deems fit to do the complete justice to the cause or matter brought before it. Your Lordship, relating to the enforcement of fundamental rights, my learned friends contended that the users of Facebook will violate the fundamental rights of judges, Your Lordship. Your Lordship, it is undoubtedly undisputed that this issue is related to the interest of general public, and it is an issue related to the national importance, Your Lordship. Hence, Your Lordship, when the issue related to the public comes, the need of the society must be felt, as it was held that in Pavanasam Labour Union, where the restriction should be put under Article 19, when restriction should not be arbitrary or excessive in nature. In present case, neither it is arbitrary or excessive, because we are only talking about those sites which are bilateral in nature. And it is imperative to consider that the need of society must be felt, and judicial approach should be pragmatic and dynamic. Your Lordship, in Krishnakant versus Government of Kerala, it was held that reasonable restriction is to be determined in objective manner from the standpoint of interest of general public, not from the standpoint of interest of the person upon whom restriction is imposed or imposed upon abstract consideration. A restriction cannot be called as harsh, although it cannot be said to be unreasonable merely because it is given, it operates hardly to a particular individual, Your Lordship. Your Lordship, regarding
general importance, you are using it in the evening. That's all.
Your Lordship, sir.
If you succeeded, you would have complained that the judge is biased.
Your Lordship, regarding bias, Your Lordship, coming to the Bangalore principles, where India was a signatory, and although these principles have been followed in reinstatement of judicial values as well as in MC Vesetalwar principles, value 2 and principle 2.2, a judge shall now ensure that his or her conduct both in and out the court maintains and enhance the confidence of the public, the legal profession and the litigants in the impartiality of the judge of the judiciary. And Your Lordship, the last contention of the council is that I would like to offer my learned friends that they should make the minds of their their client, that although maybe they would have approached the conciliation, but still, if as in the case this court has offered for the reconciliation again, so hence although there is a maybe the conciliation was failed earlier, but if with respect to K. Srinivas Rao versus D.A. Diba AIR 2013 SC 2176, it was held that the duty of family court under section 9 is to protect the marriage, to uphold the marriage, your lordship, and family court should make the efforts to settle the matrimonial disputes, even if the counselor submits, even the mediation counselor submits a failure report. Family court shall, with the consent of the parties, refer the matter to the mediation center again. Here I would again like to offer my co-friends to make the minds and resettle the issues again, and we will compromise in certain way, your lordship. And your lordship, the care of the child must be taken, because it is the development of child and it is the care of the child. They have brought the child and parent, it is the biological parents who can protect the child, your lordship. Hence marriage should not be broken, it is the ultimate contention, your lordship. Much obliged, your lordship. That's all, your lordship.
Valedictory function will commence within 10 minutes. Please be seated.